Okay, good morning, everybody. Time for part four of our first part of the Civil Liberties unit. We'll have I think, 8 total slides of information today, still about freedom of expression, and then one court case for your assignment today. And then there'll be one more lecture and one more court case before we're done for the semester. Let's get started here. So we're continuing to talk about expression, and now if you remember a few slides before, we had this list of things that are not protected speech. We're going to go through some of those things so we kind of understand why they're not protected and what part of them is not protected. And one of those was obscenity. We had libel and slander and things like that too, and we'll get to those. So the first one here, just this case, which is not part of our big number, but just to give you an idea, set up in 1957 the idea that obscenity is not constitutionally protected speech. Okay, it's not part of free speech. So the idea, of course, is, and the issue, again, is going to be who in the world decides what's obscene and what's not. And that's where it all gets tricky. Okay? And just to give you an idea, it's a humorous statement, but it's a statement made by a Supreme Court Justice dealing with this case. And he said, Potter Stewart said, I can't define obscenity, but I know it when I see it. And that's probably the most honest expression of the idea of how hard it is to try to define obscenity. And then, of course, you know it when you see it, but everybody's different. And that's where we run into all of the problems. So just on the very surface of it, we just have to sort of understand the basic idea. And the first thing to understand is we have to understand that the standards of the public about what's obscene and what's not has absolutely varied through a variety of things, varied through time. Obviously, something in 1900 that was obscene probably isn't obscene or probably won't be obscene in 2020. In place, New York City, something might be considered not obscene that really in the center of Kansas might be considered obscene. And then, of course, people, we're all different. We all probably have a different, at least a slightly different definition of what obscenity is and what it is not. So there's a standard that was set up, and this is basically as far as we have to understand it. Set up in this case in 1973 called Miller versus California. And the standard is if it violates any one of these three things, if the work, and this is where the judges and whatnot and the lawyers make their money with what these words mean, taken as a whole, appealed to the prurient interest in sex. Okay. Number two, showed patently offensive, whatever that means, sexual conduct specified by the law, or the work lacks serious literary, artistic, political, or scientific value. That last one was put in there for like scientific things, like textbooks and things like that. So if you have an anatomy textbook, obviously it's going to show parts of the human body that might be considered obscene, right? Well, so that's going to save that. So you can't call a textbook because it has human anatomy in it. You can't call that obscene. So that's sort of the idea of number three, plus other things. Is it a literary work of art? Is it political speech? Things like that. So it's complicated, but the bottom line for us is we really just need to understand, as far as obscenity goes and what's legal and what's not, is the decisions that the court said should be made by average people, which means juries, applying contemporary standards of, and not bolded, but I've capitalized the whole word, of local standards. So it's contemporary, which means by time, right? So 1900 versus 2020. Local, right? By place, locality. What's obscene in South Georgia might not be obscene in Atlanta. Okay? So it's average people and local communities with local standards. Okay? And so that's where we sit. So we got a little bit more to go through here. When something is out there, it's getting a jury to convict anybody on obscenity, possession of, or selling of, or whatever it is. It's very difficult because it's so widely available, and even more so now. So the context of this is set prior to the arrival of the internet, but with the arrival of the internet, obviously, I mean, it's available in your homes now. Usually, it's not prosecuted when everything there is restricted to adults. The issue is, of course, and as we might imagine it should be, regulations keeping children from obscenity are more likely to be constitutional, under 18 or what have you. That's where the laws can be more effective and be more likely to be constitutional, restrictions of those things. Okay? All right. So let's move on to libel and slander. So we need to define it, make sure we understand it. It's the publication of, which is the libel, or the spoken, which is the slander, of false or malicious statements that damage someone's reputation. Okay? But they have to be false. Okay? If it's true, if you say something about somebody that is true and it damages their reputation, that's just too darn bad, right? Because it's true. But if it's false, that's the problem. Okay? So let's talk about a few things. We have to kind of understand, what about lies about politicians? We hear that all the time. It doesn't matter what side it is or whatever. There are lies told about every single politician all the time, election season, what have you. Here's the thing. It's going to be basically impossible for a politician to win this argument. The Supreme Court has said the central meaning of the First Amendment is to protect criticism of government. So it's fair game for anything. Okay, a politician will virtually never. I don't even think there's ever been a case where a politician has won a libel or slander suit, even if the stuff is false and malicious, because it's about a politician, and that's just the way it is. And there's a case, New York Times versus Sullivan, that sort of sets up a little bit of this. Statements about public figures are only libelous, slander if it's spoken, with, and it's bolded there, malice and reckless disregard for the truth. Okay? So a public figure, a politician, a celebrity, sports figure, whatever, okay? Statements about them, it's such a high bar to get that there's hardly anybody that can ever succeed, because the words that they use, and these are the lawyer words, right, where they all make their money, malice and reckless disregard for the truth. Not even just disregard for the truth, reckless disregard for the truth. So, and there's meanings for that that are set up in the laws and whatever, but where the judges and the courts decide things. So, very, 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 very difficult to win a libel or slander case. Okay? Now, it's a little bit different for private individuals. For people like you and me, regular old people, it's easier, it's still not easy, for us to win a slander or libel lawsuit. The bar is not as high. Okay? So, the words they use, instead of malice and reckless disregard for the truth, they say defamatory falsehoods, and the author was negligent. That's all. The author has to not have done their work to determine whether or not that was true or not. They should have done more work to determine if it's true, and if it was false, then they shouldn't have done it, so it's their fault, and they're going to have to pay. It's a lawsuit, right? So they're going to have to pay. And there's a case, and it should be on the next slide, a Rolling Stone case not too long ago, where it shows this lower standard for private individuals. And again, it was only a couple years ago. Still, it's going to be very difficult to prove. So I'll just mention this case real quick. You don't have to take notes on this part. But the Rolling Stone magazine published this particular article, some time ago, based on the story of a student at the University of Virginia who said all this stuff happened. She was raped, and it was part of a pattern on campus, toxic masculinity, and all of that kind of stuff that's sort of in our culture today. Well, turns out it wasn't true. And in the story, they defamed one of the deans of the University of Virginia and the fraternity that the supposed assailant, who turned out not to be, that person was from. So both of those entities sued. And the Rolling Stone magazine ended up having to settle. They lost, or they were going to lose, so they settled instead with the University of Virginia dean, who they defamed, and then with the fraternity that they defamed. And so this University of Virginia dean and this fraternity, those are more private. That's where we see the idea of a lower threshold. Okay, if they were public figures, celebrities, blah blah blah, politicians, they weren't going to win that case. But as long as they were on this private level, it was a little bit different, a little bit easier to win the case, and they won, or at least they won settlements before the case finished up as a trial. Okay, last little bit. This has to do with our case today, is symbolic speech. So what's that? The idea that we have here is freedom of speech is more broad than the spoken or written word. So even though it says freedom of speech, there's more to it than just speech. Okay? And we call that symbolic speech. In this case, this will be our case today, so you'll see more detail when we do it. So just the upshot of it is Tinker versus the Des Moines Independent School District. This was from 1969. The event actually happened, as you'll see, in 1965. And it involved the school district expelling these students for wearing these black armbands to school in protest of the Vietnam War because they were told that they couldn't. But in the end, what happens is, and you'll see, the school district could not suspend those students for protesting the Vietnam War by wearing black armbands. So that's the upshot. You'll get more details in your assignment. So it sort of sets up the idea that we understand the right to freedom of speech goes beyond the spoken word, which leads us to our last slide. And that leads to a case called Texas versus Johnson in 1989. Again, it involves symbolic speech. And the image here, hope you're not, this shouldn't offend you. I hope not. Well, don't be offended. Sorry. Is this legal? This is what we do in class. So I put this image up and I go, is this legal or not to do this? And usually about half and half, yes and no. Yes, it's legal to do that. No, it's not legal to do that. Well, this was a case. Texas had a law against burning the American flag for protesting purposes, things like that. And the Supreme Court ruled that flag burning was protected speech. It is not what they call dramatic action, which was what Texas said. That's just dramatic action, and we can say you can't do that. No, it's symbolic speech. The Supreme Court, very, very unpopular decision. I remember when this happened. It was this really unpopular decision in the country. Like, what is the Supreme Court thinking? But the idea is, remember, the idea of, excuse me, hang on a second. Okay, sorry about that. So remember, the idea of freedom of speech is not to protect speech that people like or that's popular. The whole purpose of freedom of speech is to protect speech that is not popular, that is unpopular. We have to keep that in mind. Okay, sorry about that. I can't reiterate that enough, that last thing I said. We have freedom of speech not to protect popular speech. We have freedom of speech to protect unpopular speech. Because the idea is, if the government can go so far as to ban or prohibit this kind of speech, someday they're going to come to prohibit your kind of speech. Okay? So we have to protect it all so everybody is protected for all time. Okay? That's sort of the idea. So I have one more scenario then. What about a St. Patrick's Day parade in Boston? Massive deal, right? Boston, Irish Catholic, one of the Irish Catholic centers of America. They do a big blowout parade every year on St. Patrick's Day through the city of Boston. They get their permits and all of that. So one year, and it wasn't that terribly long ago, like say within 10 years, so that's not terribly long, an LGBT group wanted to march in the parade as well. So they demanded that. They demanded that they be allowed to march, and I think in the end the city said, yeah, you have to allow them to march. So the organization sued, and that organization won because it was a private organization. Okay, it is a private parade. It might not be anymore, but it was a private parade set up by private organizations, and that is protected speech to feel free to include only who they want. So again, difference between public and private. So just to sort of reiterate that point, symbolic speech and things like that. All right, that is it for today. You have one assignment, that Tinker case, and we'll move along and have one more set of lectures for this part of the unit.